Well, good morning and welcome back. I've been told we have to get going here. I'm Charles Wheeler with Clinic, and I want to welcome you to what is probably going to be another lively performance. We're going to talk about two related issues: immigration enforcement and immigrant detention, complex, controversial, politically charged, etc. Before I do that, before I introduce our panelists and open it up for questions after that, I wanted to give a short background. I started out in the late 70s when immigration enforcement was a very low priority, both at the border and also internally. Immigrant detention was almost minuscule. That changed in the mid-80s with IRCA, 1986, when enforcement suddenly became an issue, coupled with, of course, amnesty. 1990s, that in fact doubled down, became even more of a big issue with the 1997 Act, IRA, to where by 2001, you had about 200,000 people being detained in a given year for immigration enforcement purposes. That had doubled, more than doubled, by 2013, to where now we are at 440,000 people being held in immigration detention. That is 5 times the number of people who enter the federal prison system based on criminal issues. Complicating this whole issue has been the use of private for-profit contractors, GEO Corporation, Corrections Corporation of America, two of the big players. You may have read 2 long, in-depth articles in The Nation and Mother Jones this year. Very interesting spotlight on a lot of the problems inherent in these issues. Department of Justice, maybe by coincidence, maybe not. Department of Justice recently announced that it's going to cut its ties with the private contracting world, with the Bureau of Prisons. And Deputy Secretary Mayorkas hinted that, in fact, DHS is also doing an internal review to see whether they might be cutting their ties as well. Summer of 2014, as we all remember, saw a return to family detention. 2 facilities opened up, got refurbished in New Mexico and Texas to handle mostly Central American women and children. This notion of family detention was a return to a Bush policy that Obama had originally ended when he took office. Currently, there are facilities operating in Texas as well as Pennsylvania, but they are also covering mostly Central American women and children. But they're subject to pending litigation over compliance with the litigation in California, nationwide class action, the Flores litigation. So that's an issue that's going to be working its way out. As far as interior enforcement, the Obama administration showed a willingness sort of late in the game to curtail controversial programs such as secure communities, and has now replaced it with the 2014 memo that Secretary Jay Johnson wrote on particular enforcement categories, as well as a new priority called Priority Enforcement Program. That's the PEP in the title to our panel, in case you didn't know. DHS has made PEP voluntary, and certain major jurisdictions have not opted in yet. But the hope is that up to 2/3 of the major jurisdictions that were not participating in secure communities are going to join that. So with that, I'm privileged to have 4 panelists that represent both the community, the advocacy community, as well as the government, talk on different aspects of these issues. The first speaker is Stephen Manning, who is partner of the Immigration Law Group and director of the Immigration Innovation Law Lab. To his right is is Thomas Homan, who is Executive Associate Director for Enforcement and Removal Operations at ICE. And to his right is Liz Cedillo-Pereira, Senior Advisor to the Director of ICE. And then finally, Dree Collopy at the end, who is partner at Benach Collopy, co-director of the Immigration Litigation Clinic at Catholic University School of Law. So, Stephen, let me start with you. I didn't ask specific questions. I decided to have the panelists talk for about 10 minutes on the issues that they thought was the most important.
Thank you, Charlie. This is really great. I'm not sure if it's more, I was just telling this to Tom, if it's more intimidating to be in front of you all or before the Court of Appeals talking about these things. In what seems like a lifetime, but has actually only been 2 years, I've been a volunteer, and I don't know why when I get in large groups, when I talk about these issues, I still have this emotional reaction. I've been a volunteer lawyer representing women and children who've been detained in the family detention centers, first in Artesia, New Mexico, then in Dilley, Carnes, and now Berks. Along with a lot of others, we've developed this crowdsourced refugee defense model that's being used in the detention centers. And right now I'm also involved in creating these centers of excellence, using a similar legal organizing model that focuses on entire immigration adjudication ecosystems, and particularly under-resourced areas, for example, in Atlanta and in Charlotte. We've created this technology platform that's tying all of these people together, and we're now about to deploy the next generation of this technology that's going to connect border shelters, the centers of excellence, the detention centers, to really create a seamless approach to the provision of legal services to be able to make sure that every meritorious case can win every time. And sort of this model that we're calling big immigration law. As of yesterday, the CARA Pro Bono project, so that's the project right now that operates in Dilley and Carnes, has represented more than 35,000 women and children. That's in a little less than 2 years. I've been involved in the case representation within those 35,000 of actual individuals. I've been before all levels of the agency. I've done extensive programmatic and data analysis on the program, and have been involved with impact litigation, some of the litigation that Charlie was talking about. So I've had this really rather broad, interesting viewpoint across immigration agencies, across cabinet departments, across court jurisdictions, the administrative space, the legal space, the political space, and the detention space, about what the expedited removal program and its corollary, family detention, how it operates and what does it mean. And from that vantage point, I'd like to address the question, right? Like, is expedited removal, has it been a success as a program? And so expedited removal is a policy choice, and it's rooted in the government's prosecutorial discretion to remove a person from the conventional immigration court system. It maximizes the authority of the government to order detention, and it insulates nearly all agency action from judicial review. So without expedited removal, there is no family detention as we know it. So family detention, as it's implemented today, is only possible because of the administration's policy choice to use Section 235B of the Immigration Nationality Act, the expedited removal statute, as its detention authority. So 2 years ago, the administration flipped the switch on expedited removal against the Central American population, and instantaneously we had Artesia, and then Dilley, and then Carnes. So has expedited removal been, at least against the Central American population since June 2014, has it been a success? And the answer is maybe, right? And that's the perfect lawyer answer, right? It's maybe because it really depends on what is the policy that it's really driven to address, right? So what is the policy, what is the purpose behind the policy? And so I'd like to walk through just a couple different permutations of the possibilities of why we have expedited removal. So the most obvious one, right, is to expedite removal, right? That's the purpose, right, of the expedited removal program against the Central Americans, through especially particularly in family detention. I think the numbers would show that it's failed, right? So of those 35,000 women and children, probably less than 0.01% have actually been removed, right? So it's important to know that against nearly all of them, there was originally an expedited removal entered, right? But in nearly universally, all of those expedited removal orders are later rescinded. So from a pure programmatic perspective, if I were administrating this policy, this program, where nearly all of my front-end processing was being later undone, I think that's an important metric to be able to assess whether or not it's been successful. If the expedited removal program is intended to support the asylum program, right, to bolster our asylum system, right, by separating out the border entrants from who have credible claims for asylum from those who don't, I also think the numbers don't show that it's been successful, right? So by choosing to use expedited removal, this policy choice now requires us that we do 3 asylum adjudications, right? So we have a CBP threshold screening. We have we use the affirmative asylum program to do this very extensive, exhaustive, credible fear screening. And then we set it up for an adversarial adjudication before an immigration judge. And I think that policy choice has created system shock within the affirmative asylum program, right? that because of the vast resources that it takes to maintain and stage a legally credible fear screening system, the affirmative asylum program has pretty much stopped functioning in large parts of the country. Like, so in Portland, where I'm from, Portland, Oregon, we wait 4 years for an affirmative interview. Los Angeles, it's 5 years. Miami, Newark, it's 3, right? Charlotte, Houston, it's 2 years, right? Those resources that normally would have been available to manage and maintain the affirmative program are now being diverted because of the expedited removal policy choice. And so is expedited removal is the policy choice, is it about border enforcement? And I don't think the metrics hold up well here either, right? So legally, we know we cannot detain folks to deter other Central Americans from coming to the United States. That's unconstitutional. We learned that in some class action litigation around the family detention. But even if we could detain to deter, right? Our expedited removal program actually doesn't have any meaningful real-world impact or deterrence value, right? So there's credible field studies that have been done that have measured whether or not what our policy here is on detention, removal, have on people who are leaving Central American migration. And from my knowledge of the studies, it's not even a close call, right? As a detention program, I also think that the expedited removal, if we look at the numbers again, right? If we look at the numbers through a detention lens, the expedited removal program as a policy choice also seems not to function, right? So detention is only constitutionally authorized when it's in the furtherance of deportation. And so here we know that at least from these 35,000 women and children that have come through the CAR program, less than 0.01%, so that's 113, have actually been removed, right? So we know we can't detain to deter, but we're actually not detaining to deport either. And so the detention through the expedited removal program seems to be a policy in search of a purpose. It's also that begs another question though too, right? So with the expedited removal program and subjecting children, right, to prolonged detention or to detention, right, or family units to detention, what's happening to those human beings as human beings, right? Like, our empirical knowledge at this point of the effects and the impacts on families, family units, and children of the effects of detention is still very at an early stage, right? Are we causing irreversible damage? Are we stunting family and childhood development? We know right now, like we have the data showing there are children right now in Berks right now who are young kids who are contemplating suicide, right? So that's really, they're displaying regressive developmental behaviors. So to fill in this picture, we're actually beginning a more robust analysis of our own data within the big immigration law project to figure out some of the long-term impacts. And there's two other things I just want to quickly mention. So one other perhaps useful metric in determining whether or not the expedited removal program has been a success might be whether it's adhered to the rule of law, right? So has the implementation of this policy choice been legal? And if we look at the state of play in impact litigation, every time the merits of the government's policy choice has been judicially scrutinized, the implementation has been found to violate the law. The only times that the government has survived in court is when they use their structural advantage in the statute to preclude Article 3 jurisdiction, to prevent actual judicial scrutiny. The very final thing I'd like to mention is expedited removal policy through a fiscal lens, right? I became a lawyer, so I would not have to deal with numbers, right? So I'm not a math person, but I do a lot of data analysis, right? And here's where the picture becomes a little more cloudy, right? So is the expedited removal program been a success through a fiscal lens, right? So the direct costs of the border deployment, the detention center in Dilley and Carnes, they're known, right? And that's a lot of money, right? The fiscal impact in the asylum office, on EOIR, and in the advocates, the entire adjudication ecosystem, as I call it, is being weighed down by the expedited removal program and this policy choice that's made at the border. But we also know that there are some sectors who have benefited, right? So there's some positives, right? The Washington Post recently reported that the private prison industry has benefited enormously from the expedited removal policy choice. And so to answer the question that I got to pose to myself, is expedited removal, is the policy choice to use expedited removal against this population where we have 2 years worth of data to demonstrate that nearly everyone will be released because they all have credible fears for asylum. Has that been a success? I would have to say no.
Thanks. Thomas?
Well, I guess I'm up. You know, every time I do one of these things, my office prepares all these talking points here, but I never use them. I don't know why they keep doing this, guys. I just speak from the top of my head. Look, unlike most people in this room and at this table, I am not an attorney. I'm a law enforcement officer. I've been a law enforcement officer for 32 years, all in immigration enforcement. I started in 1984 as a Border Patrol agent. My old boss sitting in the front row here, Doris Meisner. I remember those days. You know what hasn't changed, though, since the mid-1980s, and I agree with your original statement, was immigration is a very divisive, very emotional topic, and that's not going to change because it affects so many people. I've been doing this for 32 years. I started as a Border Patrol agent, then I became a special agent, criminal investigator, looking at organizations that smuggle people. Now I'm at the end of my career. The last 7 years I've been in enforcement move operations, so I've actually lived the entire alien life cycle, illegal immigration life cycle, from the front line on the border to now in the detention removal phase. So I figured when I start today, I'm just going to talk about a few items, and I'll briefly touch on each of them because I know they're hot topics for discussion. First of all, executive actions and our current priorities. In 32 years, I worked for a lot of secretaries of either attorney generals of DOJ or secretaries of DHS, and I can tell you, Secretary Johnson, I admire this man and I respect this man greatly, because when we came to the table a few years ago to talk about executive actions, he actually brought law enforcement personnel to the table. He brought me there, he brought the head of the Border Patrol there, because he wanted to hear from a law enforcement perspective what made sense to us, based on our experience, what worked and didn't work. So I was actually involved with some of the authoring of these executive actions and the priorities. Did all my input make it in there? Absolutely not. But I did have some input that made it in there. And here's why I think executive actions and the priorities make some sense. If you believe the number 12 million illegal aliens in this country, let's just say we'll always accept that, 12 million. The most aliens ICE ever removed in 1 year is 409,000 back in FY12. 409,000. Do the math. That's less than 3%. So hitting on all cylinders, if we can, as an agency, based on with our budget and our resources and so forth, can remove 3% of that population, in my opinion, as a law enforcement officer, that 3% needs to count. What I mean by that, it should be a criminal before a non-criminal. It shouldn't be the first 400,000 in the door. It shouldn't be the first 400,000 we find. We need to pick and choose that 400 is, make sure it's going to be the biggest impact on border security and public safety. And I think the priorities we're currently working under gets us there. Now, you read a lot of editorials every morning. Every morning I come in, first thing I do is read all the press releases. Half of them think we don't do enough. The other half think we do too much, which means we're probably doing just about the right thing. I've testified in Hill many times, and I'm not a gifted speaker. I'm a cop that speaks to what I know, facts. Here's the facts on to those people that say the priorities is not working. 98% of those were removed last year, 235,000, fell into an enumerated priority, 98%. That's pretty close to perfect. 91% of the people we arrested last year in the interior United States had a criminal conviction. That's pretty close to perfect. Last year, 59% of everybody removed had a criminal conviction. That was a record for the agency. So those that say that, ICE isn't paying attention to their priorities, they're not looking at the numbers, because the numbers speak for themselves. We all know that morale in my agency is an issue. A lot of officers think they should be enforcing the entire INA like we used to. But my job is something I say in the Hill every time I testify. My job is to execute a mission within the framework provided me. That framework being policies, resources, budget, whatever. Execute the mission. And based on the numbers I just told you, the men and women of ERO executing the mission pretty close to perfectly. You don't have to like it, but the facts are the facts and there are the numbers. When we talk about secure communities and PEP program, I support the PEP program. And let me tell you why. Because I got 8,000 law enforcement officers that for every detainer that's not honored, we're knocking on a door. And it's a matter of time till one of my men and women don't come home. Because we are concentrating on the worst of the worst of criminal aliens. And when we knock on those doors, we don't know what's behind that door. So for every detainer is not honored, either a man or woman that works for me is knocking on a door, which is, I think you can all understand, is an officer safety issue. So the PEP program actually did bring back a lot of jurisdictions to the table. Are they back to the table in full form that used to be 6, 7 years ago? No. But even some of the most difficult jurisdictions who only want to work with us on the most significant felons, that's one less door I got to knock on. The men and women that work with me got to knock on. It's not where I think it could be, but it's better than where we were last year or the year before that. So the priority enforcement program, I think, makes sense from an officer safety perspective. I think it makes sense from a priorities perspective. One thing I'll disagree with Stephen on secure communities. The biometric capabilities of secure communities was the biggest plus this agency ever saw. And let me tell you why. Again, a real life cop example. Back when I was a special agent in Phoenix, Arizona, we arrest whoever we found. We go to the airport, we look for people we thought were here illegally, had reason of suspicion. We go to work sites. Where we found them, we arrested them. We didn't care if they were 15 years or 20 years. We didn't care if they were 1 year. If they're illegally in the United States, they're going to get apprehended, and we're going to put them in detention. Meanwhile, while we're doing that, and I'm arresting somebody that's probably been here for 20 years, got a U.S. citizen child serving in the military, there was child predators walking out of county jails and state prisons all across the country because there's no meaningful way to staff over 4,000 facilities, county jails, city jails, precincts, whatever. What secure communities did was give us a virtual presence in those 4,000 facilities. So now that child predator doesn't walk out of that jail, we don't have staffed. So rather than concentrating on whoever that we find, now we can have some common sense approach to who we want to put our hands on. Who do we need to put in detention? Who do we need to put in immigration court? So secure communities gave us that virtual presence. Now where secure communities got sideways with a lot of folks is because for those who don't know secure communities, let me just explain real quickly. If any of us in this room gets arrested tonight and you get fingerprints taken to run a criminal history check, those prints get bounced off DHS databases. If you have a prior immigration history, we're going to find out about it. And we decide whether we want to put a detainer on you or not. I think, again, I think secure communities gave us a tool to have a virtual presence in all these facilities. But where it got sideways is once we get fingerprints back and somebody's just illegally here, maybe they got a traffic offense and so forth. So there's this belief that secure communities wrapped up non-priority persons. Well, we can agree or disagree on that, but that's where the message got sideways. So under the priority enforcement program, we still have the biometric capability, but now we pick and choose who falls within one of the Secretary's priorities before we take action or either a detainer or notification form. So the biometric capability, I think, is a leap years ahead. I think that was a great thing for us to have, so we can actually know where a predator or a very violent offender is getting released from a county jail now, where we didn't have that before. And it actually focuses on the worst of the worst. Family detention, it's a tough issue. In FY 14, when Rio Grande Valley was out of control, I'm one of the ones that told the Secretary I think we need to build family detention. And you can hate me or love me for it, but bottom line is I think we're a sovereign country. We need to decide who comes in and out of this country. For those who want to question how family detention operates, under what conditions, you should go down and look at it. I've been to both the facilities many times to look at it myself. It is very costly because we have to do an educational program and we have a very significant health program that we run. We also work with CARA and give them on-site presence at the facilities with other organizations also. But right now, the average length of stay of the most families in family detention is running around 14 to 15 days. In those 14 to 15 days, we get to find out who they are. Do they want to make a claim to asylum? And a point that we forget, back before we had this, they were getting released straight from a Border Patrol station back to catch and release. A lot of these families weren't claiming fear. Most of them claim fear when they come in our detention. So if they really have a claim to fear, I think more people are getting that opportunity to claim fear now, and they can have their due process. For those that say that we're detaining people, asylum seekers, I think immigration court is disagreeing with that because immigration court is finding less than half of them to have a valid claim. As a parent, as a father, I do not enjoy detaining families. Again, but I'm executing the mission, trying to enforce the law. As far as the UAC issue, unaccompanied alien children issue, that's going on at the same time. My role is very simple in that regards. My job under TVPRA, my job is I cannot hold a juvenile for more than 72 hours without turning them over to Office of Refugee Resettlement. So my role basically is the transportation between the Border Patrol and ORR, wherever they tell us to take the child, that's where we take them. So I've read stories where ICE has spent millions of dollars transporting children to their parents to complete what some people call criminal conspiracy of alien smuggling. And I would remind the folks that say that I got 8,000 law enforcement officers that are trying to enforce the law, do the right thing, but they're doing what the law tells them to do. The TVPRA is clear what our job is take these kids to an ORR facility, not to their parents. And second of all, Congress appropriates me to do that. In my yearly funding, there's actually a line item for the transportation of unaccompanied alien children. So the men and women of ICE are doing what the law tells them to do and what they're funded to do. I'm sure OBG and OBR will come up. Operation Border Guard and Border Resolve that we did in January and February. Again, we come up with an operation, a targeted enforcement operation to look for those people that had final orders removal or outside the appeals process. They had their due process. They got a final order. One of the things we'll talk about today, I'm sure we're going to talk about is due process, people having their right in court. Well, we got to remember when they do have their day in court and they do get a final order from an immigration judge or from the BIA, whoever, my job is to execute that order. Again, it's not a matter if or can or should I. That is my job to execute that order. So the folks that want the due process of law and stand by the laws of this country, well, once you have that due process, you get a final order, and that my job is to execute it. Then that's what needs to be done. OBG and OBR, one thing you not read in the paper, number one, they're not neighborhood raids, which people call them. They're targeted enforcement actions. We know exactly who we're looking for and exactly where we're going. We don't go to schools. We don't go to, community events. We go to an address that we have looking for a specific person that we have a remove order for. So there's no neighborhood raids. One thing you didn't read during Operation Border Guard and Border Resolve, we actually walked away from many families where the mother was pregnant or had a breastfeeding child. You didn't read that in the paper. The men and women of VRO did an excellent job in this operation. A lot of prosecutorial discretion was shown during that operation, which you didn't read about in the paper, but I'll share with you today. Many families, we located them, and we chose not to arrest and put in detention because of health issues, breastfeeding babies, or the mother may have been pregnant. The whole detainer issue, that's be my last thing I'll talk about and just throw out there. I think the PEP program makes some sense on the detainer issue. We now have to show probable cause that this person is removable from the United States and that they're a convicted criminal. The notification form basically asks the law enforcement agency, do not hold this person 1 minute longer than you normally would hold him, but please let us know before you release him. So I think that gives the law enforcement agencies a different option. And as far as the detainer issue altogether, it's being litigated in several places throughout the country, and we'll let the courts work that out. But I'll share this with you, what my thoughts are on this. PEP brought a lot of people back to the table, and I'm grateful for that. There are some jurisdictions who are not back to the table, and we'll keep working with them to bring them back to the table. But at some point, if they don't want to come back to the table and work with us, I think there needs to be some sort of mandate that they work with us. Because on one hand, you can't have the Department of Justice funding SCAP at the same time not cooperating with the other branch of the federal government that's charged with enforcing immigration laws. So I'll leave it at that. I just hit on the basics. I'm sure I've got a lot of questions coming. So I just want, this is my thoughts. I mean, I've been doing this a long time, and believe me, it's emotional for me as it is for you. Anybody thinks that, I'm sitting in D.C. and I'm a heartless person. It's nothing further from the truth. And a lot of these decisions are decisions based on fact, and based on what the rule of law is, and it's a tough job. I got a tough job, and anybody doesn't think so, come and sit with me for a day. Come and sit in this audience today. So that's where I'm at. That's the facts as I present them. I'd be more than happy to take any questions you may have or comments.
Thanks, Thomas. Liz?
Thank you, Tom. I think this man deserves a round of applause just for sitting with a table full of lawyers. I think one thing you'll find with Tom Homan that he's both candid and transparent, and that's why it's an honor to be your colleague. Thank you. And join my other colleagues from DHS and ICE here today. Thanks for being here, and old colleagues with Catholic Charities and the NGO community. As Charles said, I am Liz Cedillo-Pereira. I'm the Senior Advisor for Director Saldana at Immigration and Customs Enforcement, and I come from Dallas, Texas, originally an immigration advocate and prior to joining ICE about 1 year ago, practicing immigration law in Dallas, Texas, where I was very happy with my family and kids and home and business. But the director called me up one day and said, I'd like for you to come join me in DC and help make a positive contribution at ICE. And I thought long and hard about it, and the idea of serving the public good was very appealing to me, and really quite eye-opening from an advocate's perspective to see all the nuances that go into the decisions that must be made at this level. Quite eye-opening, and it's a tough job that Tom talks about that he does every day with a lot of, I think, virtue and strong leadership. So thanks, Tom. Also good to be back with Charles Wheeler. You may know from Charles's role at Clinic that he's trained probably quite a number of us here. If I asked for a round of hands, it'd probably be like at least 20. I'm one of those Charles Wheeler fan club members. When working as a detention attorney for Catholic Charities early in my career, he was actually often my red phone hotline to understanding the nuances of immigration law back when mandatory detention was just coming into play in early 2000s. And so I call him the Steve Jobs of immigration law. It's great to be with you.
Still alive, though.
Yeah. And kicking. So it's good to be here. And you may not have known Tom before, but now you do. That's what my role here was, to be Introduction to Tom Homan 101.
She's kicked me 3 times in the table, so you know.
That's right. But you may not recognize his face, but his name is well known. He's the signator to quite a few memorandum that I think are significant, like the treatment of transgender and pregnant women in detention facilities, and one that's coming out this week about custody decisions related to the treatment of individuals with special vulnerabilities. So the guy might talk a tough game, but he does, as he said, have a heart. And he looks at everything, and he balances and weighs those people who are in our custody. So I'm glad to be here with Dree and Stephen to have a useful discussion on how do we take the ball and move forward with all these tough issues that are before us. As you've already heard Tom discuss, PEP and family detention somewhat, I'd like to elaborate a little bit on the exercise of prosecutorial discretion, as this is an area where I play a direct role in Director Saldana's office. The one thing we're always asked about is how do we use PD, or do we even use it? Sometimes we're asked for a roadmap on certain types of relief. However, the truth of the matter is there is no magic formula, no miracle cure. Our officers and our attorneys exercise this on a case-by-case basis, as you've heard us say oftentimes, and an individual matter, and no 2 cases are the same. But what I am here to say is that I do see that we're weighing the cases, we're weighing all the factors in these cases. And back in Dallas, Texas, I was known as, as among the chief counsel, as wearing them down, always wanting to exercise PD to the extent that I could, knowing how hard it was to get relief before the courts. So I know that sometimes attorneys don't like the decisions that we make related to their clients. But what I want to do is to encourage lawyers and stakeholders, accredited representatives, law students who are practicing in this area to really work with our local field offices to see if additional information can be presented that what may alter the outcome of the case. I often deal with colleagues at DHS who ask me to look into the matters, and we send it down, we ask them to take another look. Did they weigh all of the factors that go into the Secretary's prosecutorial discretion memos? And they do indeed. Sometimes the outcome comes back the same, and other times it's changed. But the only way we can know that is if you have a decision from the field office, because the director really credits her field with being able to handle these cases. And so if there's not a decision made, we ask that you please respect that process and talk to your field, whether it be the field office director or a chief counsel or the assistant chief counsel. And once the determination is made and you are not in agreement with it, then you can use the system that we have here in headquarters to escalate a process. We do have an email address, which is kind of long, but I'll say it anywhere, ERO, Prosecutorial Discretion Inquiries at ice.dhs.gov, or to the OPLA mailbox in your area, which can be found on our website at www.ice.gov/immigration action. And we will take another look at it. We'll talk to the field about it and see if there's something that was missed. We want to be as transparent as you see, you know, Tom is as honest as he possibly can be with our stakeholders and the attorneys that we work with and law enforcement in general. And speaking of transparency, that's one big task that Director Saldana has asked me to handle, to oversee, to make sure that we continue at ICE to grow our engagement with all communities and groups. So being interactive with and listening to our stakeholders is a major initiative of Director Saldana's. She asked me to build out our new Office of Community Engagement. We have an Office of Congressional Affairs, we have an Office of Public Affairs, and now we have an Office of Community Engagement. And we've come a long way with it. We're about halfway to building a team of a team of community relations officers, or CROs, in each one of our field offices. And Tom Homan was a big proponent. He said, "Hey, we need 2 in every field office." I said, "Wait, whoa, hold there, Tom. We don't have the resources for that, but we are." But he is serious because he wants his officers. He supports ICE chief counsels and special agents to have a conduit to the community so that the community can be heard and we can deal with issues at the very local level so they don't become giant issues at the headquarter level. So we want these CROs to communicate with our communities and to be able to bring back to us information and also share information back with the community itself. So we're about halfway there, as I said. We should have 24 community relations officers located in every field office at ICE, onboarded by the middle of October. So do us the favor and reach out to your CRO and see how you might be able to enlighten them about what the issues are that are going on in your local community. So thanks very much for your time and attention. I'm happy with Tom to address any questions you might have today.
Thanks very much. Dree?
So thank you, everyone, for having me here today. I'm honored to be on this panel with these 3 distinguished individuals. I want to start by first expressing my appreciation for the efforts of both of you to keep our country safe. I fully understand that governing is hard, and not many people will take on that task. So, but I also want to say that from Stephen and my perspective, our job, I believe, is equally important in giving a voice to people who otherwise would not have that voice. And so I hope you'll receive my remarks today from that lens. I also appreciate the administration's focus on prioritizing removals of criminals and people who could be a security concern. But I do believe that there are problems in this implementation of that. First of all, there seems to be a disconnect oftentimes with what's happening on paper in policy memos with what is actually happening on the ground with the officers who are charged with implementing those policies. And additionally, my thought is that one of the enumerated priorities for enforcement is recent entrants. And many of these recent entrants are refugees and asylum seekers. I'm an attorney. I have a private practice here in DC, and I focus my practice on asylum work. And like Stephen, I have volunteered with the CARA Pro Bono Project and done a lot of work in the family detention context. So for me, that is a priority that I think is problematic versus focusing on criminals and those who are security concerns. And the result of that priority is, in my view, the criminalization of asylum seekers and the denial of access to our asylum system for bona fide refugees. So I want to use my remarks to show you kind of what this is looking like on the ground and ask that you consider what I have to say in the lens of Deputy Secretary Mayorkas's framing question in the beginning of the day about who do we want to be as a country. So I'd first like to address the Obama administration's enforcement choices as they relate to asylum seekers, particularly those from Central America. For me, this is a serious refugee crisis in the Northern Triangle, and it has resulted in women and children fleeing in fear for their lives. When they get here, they are faced with expedited removal, detention, and all of these enforcement policies that I think have merit in their idea, but in their implementation maybe have failed. First of all, something that has been quite interesting to me from a policy perspective is the inconsistency in the administration's dealing with this refugee crisis in Central America based on where the people are located. So, for example, if people are outside of the U.S. in the region still, the Obama administration has called this a humanitarian crisis. It sent Vice President Biden there to meet with leaders to address the violence. It has warned U.S. citizens not to travel to the region and even suspended its Peace Corps operations. It has called for increased refugee assistance and worked with UNHCR to develop in-country refugee referrals and an emergency safety zone in Costa Rica. It has also implemented the Central American Minors Program. And so we have all of that happening in the region, yet the people who actually arrive at our border to seek protection, there's a completely different rhetoric and a completely different set of policies that they are facing. So, for example, of the rhetoric, ironically, in June 2014 on World Refugee Day, the Obama administration announced that it would be increasing its use of detention of asylum-seeking families arriving at the southern border, specifically stating to deter others from illegally crossing into the United States. We had Secretary Johnson stating that our message to this group is simple: we will send you back. And then again, that rhetoric has been implemented into detention of this population, rocket dockets prioritizing these cases to get them through the system as quickly as possible, and raids on largely Central American families, overwhelmingly. And while certainly we can recognize that not every Central American who comes here is a refugee, what concerns me most is access. So being able to access our asylum system that we have set up. Are we detaining the right people? Are we proud of the conditions in which we're detaining them? Those were some of the questions that Deputy Secretary Mayorkas posed earlier, and asked that we use our national identity as a guidepost for answering those questions. So I'd like to share a little bit about what I've seen in those facilities and ask that you consider that through the lens of who do we want to be as a country. I've seen inhumane conditions, including inadequate medical care, degrading and abusive treatment by the guards to the women and children, the need of these women to recount stories of the horrific violence they've suffered over and over again, whether it's to CBP officers, to asylum officers, then to pro bono attorneys, then to immigration judges, most of the time in the detention context in front of their children. Some of these problems, of course, have begun to be addressed, which is great, and we're making progress there. But the nature of family detention requires the telling of these stories. For example, I did an intake interview with a woman who described being raped and brutally beaten by her husband while her six-year-old daughter sat next to her coloring. Those are some of the scenes that, if you volunteer in these facilities, that you see. And it's not just one person, it's every single person I talk to have suffered horrible violence like this. And and then face, once they get here seeking protection, this monster of detention and enforcement. Detention in these conditions has been proven to compound the trauma that the women and children have suffered in their own countries. Social service providers, religious leaders, psychologists have all agreed to that fact. It also has serious due process concerns. Access to counsel and interpreters is, if it weren't for the Cara Pro Bono project, it would be impossible because these detention centers are far away from any metropolitan area with pro bono NGOs and other pro bono attorneys who are addressing these issues. Interpreters, there's huge issues there, not only for Spanish speakers, but many of the women, especially from Guatemala, are indigenous, and it's nearly impossible to get an interpreter and use an interpreter in the context of family detention. Their access to witnesses and evidence, to their family emotional support, and to mental health care are also impeded by the detention context. And so, from my view, using detention for asylum seekers is not a policy choice that should ever be made. These women and children are not criminals. They are fleeing to seek protection and to survive, to save their lives. I never would be an advocate for open borders, but detention, in my view, of asylum seekers is simply not the answer. It violates our domestic and international legal obligations not to return refugees back to persecution and torture. And it's not effective as a deterrence mechanism. These women, like I said, are coming here to survive. They're not going to be deterred by needing to be in jail. It's also quite expensive to taxpayers. One thing that I couldn't help but think about when I was volunteering in the centers was, this is where my taxpayer money is going to detain this 4-year-old child. It costs $159 per day per person in immigration detention, which is up to $5.46 million in any given day. ICE has an annual detention budget of $2 billion. So just thinking about kind of the financial implications of that when there are other alternatives that might be equally effective for enforcement purposes is fairly mind-blowing. And so for me, I see this family detention concept and expedited removal as a smothering of due process and a barrier to access to our asylum system. And I think the answer is this who we are as a country? I think no.
Thank you all. We're going to open it up for questions now. So please come to the microphones with any thoughts, comments, questions. I have a sort of a follow-up to your last statement, Dree, which is the notion of alternatives to detention. And maybe we could get all of you involved in talking about that. What is out there? What is the alternative to holding people for now 14 days, says Tom, longer, I think, in other situations? What's been tossed around? What has worked?
Well, let me talk about a few things. First of all, detaining of asylum seekers, again, they can claim asylum, but at the end of the day, less than half of them are getting asylum approved by the immigration courts. Once CIS finds a positive fear finding, we work toward release. So we certainly, if CIS, while they're in a facility, says we think they have a good case for asylum, we're certainly not detaining them needlessly. That's fact one. As far as alternatives to detention, well, let me say this first of all. Between 300 and 400 persons a year come through our system. I'm funded for 34,000 beds. So we detain a very, very small fragment of the population we run into every year. So I think it's like 1 in 12 people actually see a detention bed at any time during the life cycle. So we detain very few of the people we detain. But there is alternatives to detention. Many people that are released, depending on their community ties, depending on do they have a criminal history, depending on a lot of different factors, we decide if they can be released on alternatives to detention, which could go from ankle bracelet with GPS monitoring down to telephonic reporting, to home visits, to office visits. But when it comes down, if you look at the people we removed, and it's, again, the numbers are the numbers. We remove people we detain. People that often go on the non-detained docket either fail to appear in court, or after they get a final order, we can't locate them. Like the latest Operation Border Guardian, Border and Resolve, most of the people that we went to go look for either never lived at that residence or have since moved in that residence once they got a final order. So if, at the end, after having due process to execute that final order is difficult many times in a non-detained setting. Not that we should get away from it. I think alternative detention has a role in what we do. It's an important role. We actually, Congress has increased our alternative detention funding each year in the past several years, and we have maxed out that alternative detention. So it's certainly an option that we use, and it's successful in some circumstances, not always. But what we find with alternative detention, especially those on the higher levels of alternative detention, their appearance in court are generally high. But when it comes to final order, those numbers significantly decline. So it's an option we use every day.
Steve?
So one, I wanted to say that PEP as an officer safety program is actually really intriguing. I actually never thought of it like that. I think that's a really very insightful sort of way to think about it. The alternative to detention is not to detain, right? So we don't have to use 235B detention authority against this population. We can use 236 authority, which actually allows for independent, like the immigration judges, actually to make custody decisions in a more transparent process. Totally believe in due process. That's like process is like my lifeblood, right? And just a couple of numbers about process. So the government was forced us to litigate to the merits several cases in both Artesia and Dilley. And so we didn't choose we had universal representation. So we represented anybody who was there. We didn't screen out anybody like weak case, strong case, anything. If you were there, we represented you. And so in Artesia, we had a 98% grant rate on the merits of asylum. In Dilley, we have a 100% grant rate on the merits. I think those are really, really important, right? Again, we're not screening out weak cases, strong cases. We're taking every case the government gives us. In the raids of the Operation Border Guard or Border Guardian, there were like more than 100 women and children that were picked up, and generally from some of the very, very, what I would call hostile jurisdictions, where we're building these centers of excellence. And they were taken to Dilley, and we said, we will represent every single one that's here. Can we just talk to them? And the administration was actually pretty forceful about preventing our access. But we were able to invoke some litigation to gain some access. And for everyone who we gained access to, we represented, right? Again, so we didn't screen, we're like, okay, you got access to us, we're representing you. And in each one of those cases now, we have a 100% win rate on those cases, right? So those are all people with final orders. And we were actually able to show that there actually been a fundamental failure in the processing of their cases to undo those final orders.
I would just like to add, Charles, that we do have a family case management program, and we have our special advisor, Natalie Limerick. Would you raise your hand, Natalie? She's here today. And so this program is actually a pilot program, but we were at one of 5 metropolitan regions, and it is an alternative to the detention setting where people with special vulnerabilities are assessed. The whole premise of it is of course, court compliance and compliance with any removal order that comes into play. But we're using a set of tools through case managers who are trained in this area to have people comply with their obligations to attend court, so we're not dealing with the high in absentia rate that we have seen historically.
And one point of clarification on the Dilley operation. First of all, they were given access to attorneys. However, you got to keep in mind that if they have a G-28 on file from an attorney, we certainly can't just freely make them available to an attorney that isn't G-28. They are represented by their attorneys. But we worked through that, and I think we got to a good place. As far as 100% success, that's not accurate. There was 100% success on a group of families from El Salvador that the BIA took untimely appeals, which is outside what they usually would do. So it certainly surprised us. I think it surprised a lot of people. And those cases are still being litigated. I think it just recently settled up in Pennsylvania. in favor of the government. So I think there's, again, we certainly want everybody to have the due process. We do not want to remove anybody from this country unless they had due process. That's something we pay very close attention to.
First question.
Yes. First, just really quick, I'm one of the trained by Charles that Ms. Cedillo mentions. That's,
Gosh,
a
I
little
don't know what to
shout out
say.
there. I was actually just hoping, Mr. Homan, you could comment on something that Ms. Collopy mentioned in passing, what an apparent disconnect between guidance coming from the top and what we're seeing on the ground some. And just some examples that you gave, I wanted to add just a personal perspective to see if you could comment on, which are the idea of having an enforcement voice at the table when something like executive action is happening versus, officers bringing suit, individual officers bringing suit against the administration, or, like you mentioned, the implementation of secure communities, where I can see the value that of having that when you show it that way, of having the connection with the fingerprints, but then the use, the decisions actually getting made on the ground of who gets detained. And then you mentioned also that having that extra line to catch claiming fear when it's not being claimed at the border. When I'm in Dilley, I'm seeing on paper a lot of 3-year-olds who are saying they're coming here to work. And so that disconnect between those agents they're meeting first, having been so long in the agency, I was curious, have you seen that change, and also in your time there, and what's being done to address that if it is an issue?
All right, a couple of issues there. First of all, implementation versus policies. I hear that all the time. Like, we got a lot of law enforcement officers out there, none of them, they're all doing a great job. And, and are we perfect? No. However, the numbers speak for themselves. Again, last year, 98% of everybody removed fell within a priority. 91% of the people we arrested in the United States had a criminal conviction. So we can do the one-offs all we want, but as an agency, the men and women of ERO are executing this policy pretty close to perfectly. Are mistakes made? They probably are. But as an agency, I think we're performing very, very well. Again, the numbers are the numbers. I don't make them up. These are numbers we report up to the department every year. As far as those claiming fear, 32 years experience, I can tell you, and I testified in front of Congress about this. Do I think some of these families are escaping fear? Absolutely. Do I think all of them are? No. Do I think some are taking advantage of a low threshold system? Absolutely. And I think the numbers out of EOIR support that. Not all these families claiming fear, win their cases because they do not have the case to support it. Again, I want to make sure they all get their due process, see the immigration judge and BIA, but at the end of the day, when they get a final order, my job is to execute that order. So I certainly do not think 100% of the families coming from Central America are escaping fear. I don't. I've been to Guatemala, El Salvador, and I've been to Honduras. They're not good, they're not nice places. And so there's, again, we're a nation of laws, we're a sovereign country, and we just can't open the doors to everybody in the world to come here. There are rules. And if you look at, let me speak generally for a minute. In FY12, we removed 409,000. Last year, we removed 235,000. We're removing about half what we removed several years ago. And even when I throw the metrics out at 98%, 91%, it's like it's not enough. Well, when's enough? We have to enforce the law. If people don't like the immigration laws on the books, then that's something you need to speak to your congressional representatives about. But we're just simply trying to execute a mission that makes sense. And I think prioritization we talked about makes sense. Yes, law enforcement professionals were at the when executive action being talked about. Like I said, did all my input make it in? Certainly not. But I had some input that made it in there. And basically the criminals, making sure that all the levels of criminals. Some people say, well, misdemeanors isn't that serious. Well, it depends on what side that misdemeanor you're on. If you're the victim of that misdemeanor, it certainly makes a difference. So for the people that enter the United States illegally, first of all, it is a violation of law. It's not an administrative issue. 8 U.S.C. 1325, illegal entry in the United States. So, and on top of that, to commit another crime against citizens in this country, and if it's a misdemeanor, that is a public safety threat. A lot of times we talk about DUIs. People don't think DUIs are serious. I take difference to that. I think DUI is a public safety issue. So I think what the Secretary has done is given us a set of rules to work by that makes sense to prioritize the worst of the worst first. And again, I'll leave it at this every time. The numbers speak for themselves. People can have opinions how we implement this, and mistakes are made. But at the end of the year, the numbers speak for themselves, and the men and women at ERO executing the mission pretty close to perfect.
Thanks, Don. We have time for one more comment. What would you have asked if you could have?
Well, just a little question.
Yes.
Directed to Mr. Thomas. I really commend the work you do. Really, law enforcement is a difficult work. My name is Kosisi Ocho from Washington College of Law, and also representing the Sub-Saharan African Christian Coalition in the region here. One of the issues that have plagued law enforcement is how the community that is served feels about the work that the law enforcement is doing. And we see how much you're trying to do to help, and even picking and choosing in order to implement the policies that have been given or turned down to you. But the reality is, for those of us who practice immigration law, when you go to communities, immigrant communities around the country, and you mention ICE, it sends a shockwave. People are fearful of ICE officers, even those who don't have any immigration problems. And so, but I'm having trouble reconciling the effort you're making to do your job in a way that is humane, and then how the community feels about the work you're doing. And so my question is, do you recognize that, one? And second, do you have any plan or policies to make sure that the communities that you're trying to keep safe, including immigrant communities, understand the policies that you are implementing? Are you including them into the implementation of these policies so that they may feel that this is not just to oppress us, but it is directed to remove from among us those who might turn around and harm us?
Thank you. And unfortunately, we do not have time for an answer. I want to
That's
thank
why we
our
started our community engagement office. Thank you for the question.
Yeah. And I want to encourage you to stay. Thank you, panelists, for a very lively presentation, as promised. Please stay. Our next speaker, we're very fortunate to have Senator Durbin. So please stay put, and that's our next show.